I'm Lindsay Mignano. Thanks so much for joining us today. I have my senior tax counsel, Jason Galek, here. Jason represents both startups, individuals, and investors here at the firm. And I've got a question to bring up on behalf of our investor clients. Here at the firm, some of our counsel have clients who are pre seed or seed stage venture firms. They're usually micro venture firms and they invest really early on in a company's life cycle. But as you may know, in the past couple of years, companies have been getting acquired earlier than ever, sometimes even at Series A, being a very common inflection point. So these pre-seed and seed investors, their questions are whether their safe note, which they use to invest in this company before Series A, which is not more than, a few years old sometimes. Sometimes it may be over, 5 or 6 years old, depending on whether they invested at pre-seed or seed. When does it trigger QSBS? Is it at the time we enter into that safe note with the startup, or is it at the time that it converts at Series A? Because now with these companies getting acquired earlier than ever, figuring out whether or not I, as the micro venture capital firm investor in this company, get QSBS tax treatment upon the sale of my shares is now becoming more important. It's becoming a question that comes up more often. Jason, I know you wrote a wonderful scholarly treatise on this. I'm wondering if you can go ahead and give us the quick and dirty TLDR on what investors should be considering.
Sure. Thank you, Lindsay. So safe notes themselves they're not really characterized, or they haven't really been determined by the IRS and the Treasury to be valid for QSBS purposes on issuance or on conversion. And that really is the tension here. And so the conservative interpretation based on just existing authorities is that there's no question that on conversion, it's QSBS. But if you were to make an argument that it's QSBS eligible on execution, then that is a more aggressive position. It's not to say that it's unjustified, but it does require more careful documentation and a more careful planning, and assuming and accepting the risk that in the near future the IRS could determine that these are QSBS eligible only on actual conversion. So it's an unsettled area of tax law, and it's on the IRS's radar. They're really going to, in the next few years, start fine tuning QSBS, and this might be one of them because it's so prevalent for safe to be used for investors. So it's bound to be addressed at some point, just a matter of when. And it's better to be in front of that than and planning ahead rather than behind too late and then trying to react and respond. So it's really an opportunity to bolster your own position, to strengthen your own position, and really plan for the future as much as you can. And there are some strategies that you can do to minimize the risk, but really it is an unsettled area of tax law.